together the proposed findings and work with respondent on something that would be workable for you. So I focused on that rather than on the testimony of witnesses in writing. Hopefully this is a straightforward enough case that it won't require lengthy testimony, but the district will present testimony from both compliance and engineering for you this morning. I'd like to highlight just a couple of features of this case in particular. The primary violations that we're talking about here are of Rule 1420.2. This is a complex rule that was adopted less than 3 years ago by our governing board. Requires more rigorous monitoring and controls and housekeeping than ever before imposed upon lead facilities. We have some violations as well of the district's permitting rules. In all fairness, I'll tell you, these are disputed but not contested, fortunately, by the respondent. The major problem with this case, though...
Sorry, we're obviously experiencing many technical difficulties this morning. Do you want to go off the record and call Paul? While we're figuring that, I'm going to take this opportunity to remind everybody to please silence your cell phones. I know this is not a cell phone issue, but... Okay, but for now we can proceed? Okay, sorry, Ms. Fellman, for the interruption.
Perfectly all right. I'll give it another shot. The major problem from the district's perspective with this case is that we have no monitoring data. The respondent has not yet installed the monitors at the facility, and unlike at other facilities, this is not a situation in which the district has its own monitors located nearby or slightly off-site. Given the high demand for monitors lately by chrome facilities and other lead facilities, this is completely understandable. But without the monitoring data, we're not here to establish an emissions violation. This is not an emissions case. We don't have the evidence to support that allegation, and we don't have any reason at this point to believe that the respondent, is in violation of an emissions limit. The good news here is that we do have a very cooperative respondent who is determined to get into compliance. The facility is located in a highly industrialized area, so there are no sensitive receptors within 1,000 feet of this particular place of business. The stipulated order for abatement contains requirements for monitoring, curtailment, installation of a new bag house, installation now of a centralized vacuum system, which you will hear about. The compliance dates are keyed off the issuance of district approval of the monitoring locations and permits that are necessary to proceed. All of these processes will be expedited. In fact, the respondent has already submitted permit applications and included fees for expediting the processing of those permits. Once the monitors are installed, we will have the assurance that that a curtailment provision, which is included in the stipulated order, will ensure against any high lead emissions from this facility, which to date are unanticipated. Let me assure you again that based on what we know about this respondent's operations so far, we do not anticipate any unacceptable levels of lead emissions from the facility. The district will present the testimony of an inspector from our compliance division who is familiar with the facility. She will be able to give you an overview through a PowerPoint presentation of the facility, its location, the kind of equipment they have, and a general description of their process. I'd like you to be aware, however, that the respondent is here, he's present, and he's far better equipped to explain to you and this board what this business does and how he does it. So if you have any detailed questions about process at this facility and how things are done and the kinds of product that he produces, I do request that you save those questions for him. We will also have a district engineer available who will be able to testify about the status of the pending permit applications. So with that, I do urge the hearing board to carefully review the proposed findings as we have submitted them to you and to adopt them as stipulated. Thank you.
Thank you, Ms. Feldman. Mr. Williamson, your opening, please.
Mrs. Feldman has covered everything that I was going to include in my opening, so rather than waste the time of the board, I will just hold for closing if there are any additional points.
Thank you very much. That's appreciated. And Ms. Feldman, you may call your first witness then.
Yes, thank you. The district calls Inspector Kim Bolander. If you would please state your name and spell it for the record.
Kim Bolander, Kim Bolander.
And what is your position here at the district?
Air Quality Inspector 2,
How long have you held that position?
the best part of 30 years.
And have you taken the oath this morning?
I have.
Are you familiar with industrial battery engineering?
I am.
And have you reviewed the order for abatement?
Yes.
Okay. I understand that you prepared a PowerPoint to aid the hearing board as a visual.
Yes, I have.
Okay, could we start that, please?
Yes.
Okay,
Is it on there?
can we? It's not going to be up there, is it? We can't see this monitor. It's not up yet?
Okay, it is now up.
Okay, very good. Could you please explain what we're looking at in the first slide?
Okay. This is just a general overview of the neighborhood surrounding Industrial Battery.
Madam Chair,
Excuse me, sorry, Senator.
do you have any copies of these PowerPoints?
No, we explained before the hearing started, we do not have copies. We did offer to delay the hearing in order to make copies, but we're assured that viewing on the screen would be sufficient.
Are you sure?
That's entirely up to you, Senator. Sufficient for me.
If there are any issues as we go through, let us know.
Okay. All right. So basically we have, here's DeGarmo Avenue here in Sun Valley, and the facility is marked with this red point here. The address is 9117 to 9121 DeGarmo, Sun Valley. So we have, this is the enclosure building here where most of the battery manufacturing takes place. Well, actually all the battery manufacturing, except for the formation stage, takes place in this structure here. The building is surrounded by mostly, or the business is surrounded by mostly, there's auto dismantling, there's auto wrecking, some salvage yards. There's a MRF or two around, a transfer station, several concrete ready-mix plants are in the area too.
Okay, can we go to the next slide, please?
I'm sorry, just because the map is up, if you don't mind me asking just a really quick question. How close or where on the map is the closest resident to the facility?
I have that on the next slide.
Okay.
Okay.
Now, and then I will refrain.
Okay. Oh. All right, so this is actually, this shows the nearest sensitive receptor. Again, we have the facility here. Here's Industrial Battery. And this here is the distance to the nearest sensitive receptor. There's a little residential area here, and that's about 1,225 feet from the facility.
Okay, you can proceed.
All right, here's a process flow diagram of the manufacturing process. So let's see, we start with lead ingots, and those are melted in a lead pot. The molten lead goes to a grid casting system, and grids are produced in the grid casting device. And I will show photos of this different equipment as well. Molten lead is also hand poured in a small parts casting operation as well. On the other side, and then there's a bag house system to control this process here, an existing bag house system. Additional equipment includes this lead oxide storage silo, material, lead oxide, dry lead oxide, is taken from the silo and blended in a lead oxide blending system. And that wet material is pasted onto the grids and then dried in this equipment. Once you have a pasted grid, we call it a plate. So you might see some back and forth between grid and plate. So I just wanted to clarify that point. There's also an additional, some currently unpermitted plate stacking, post-burning, group burning, and assembly processes where an application has been submitted to permit those processes. And these are to be vented to a new bag house, which is on site and has an application, but it has not been installed. The last step in the manufacturing process to produce the batteries is there's an exempt or rectifying process. They call it formation, where you take the cells, put them together, you add some sulfuric acid, and then you rectify it for some time.
And have you seen the finished product?
Yes.
Can you describe to the hearing board what sort of battery this facility produces?
Oh, it's a forklift battery. They're very large, so I believe anywhere from 1,000 to 3,000 pounds each, because they're used as a counterbalance on a forklift.
So these are not batteries like you'd put in a car or a golf cart or a boat?
No. And I have a photo of an almost finished one at the end.
How many batteries are produced at any one time?
Probably maybe a couple a day.
Okay. You can go ahead.
That's great. All right, so here we show our raw material. So we have lead ingots here. This is our lead melting pot, and this is the grid casting machine here. You'll see ducting from these devices. I'm sorry, I left out the small parts casting. This is a hand casting operation where they take the molten lead and pour it into certain other parts that are used in addition to the grids in the batteries. So you see, so this ducting here is connecting to air pollution control equipment. I'm going to show another view of the same equipment just to get a better idea. So we have, once again, here's our raw material, lead ingots. We have small parts casting. There's the hood to the small parts casting. We have our lead melting pot here. We've got our grid casting machine. I think you have a better view of how the metal gets over to here, and where we're going to have grids that are going to be a component of the battery comes off this grid caster.
Yes, any clarifying questions, that would be great. No?
Where's the bag house in there?
It's outside of this enclosure building, and I do have a photograph of it towards the end.
You mentioned the melting pot, and it's kind of dark up there, so I could not identify it. Next time, put an arrow on it, say,
Oh.
that's the melting pot.
Okay, shall I circle it? Does it help if I circle it here a bit, or?
Okay.
It's about a 2,000-pound capacity pot inside of here. So,
Okay, go.
okay. All right, and this is, I wanted to show a grid coming off the grid casting machine. So we do have a little bit of some small burners in here to keep the metal, back in here actually, molten. And this machine sort of stamps out this grid design here. And then we have our lead metal grid.
Senator has another question.
At what point do you get emission? Is it grinding, casting? At what point are you getting emission, so-called?
There's no grinding. At this, I guess it would just be any fumes coming off the top of the,
Where?
oh, let me go back, because this doesn't show the, okay. So emission points would be, as you're pouring, in these photos, when you're taking molten lead and you're pouring it into a mold, you can have emissions there. And so that's why we have this ducting, this hood and ducting going to the baghouse system. You can have potential emissions in the burners underneath the lead metal, the melting pot. You could have the potential for lead dripping out into the burner system. So that combustion chamber has to be vented as well, and then coming off the top of the melting pot too. So that's why these are ducted to that. And then over here, when your molten lead goes into this casting system here, you could have lead emissions that
Thank you.
require collection. So, yeah.
And as long as we're talking about sources of lead emissions, at this and indeed every lead facility, we have the opportunity for fugitive emissions as well from dust.
Yes.
Yes, and is that why there are housekeeping provisions in Rule
Yes.
1420.2?
Yes.
Okay. You can proceed.
Okay. All right, here we have the paste, if you will, that's going to be applied to the grid. So we have there's a, outside of this area here, there's a storage silo that has lead oxide. And the dry lead oxide is, sorry, this isn't super clear, but there's a hopper that lead oxide feeds into, and then there's a mixing station in this system here. During this process, some water and some other materials are added to make sort of a paste. Now back down here, the paste, paste is applied to, we have our grids that just came off our grid caster and have been stored up, and then maybe once, twice a month, they'll use this machine here to apply paste to these grids, lead oxide paste, apply to the grids in here, and then there's a drying process through here.
And again, I'd like to remind the board that the respondent can respond to any questions you might have that would go into more further detail about exactly how this works.
I'm sorry, Senator, can you repeat the question into the microphone?
Would you get emission during the drying process?
Yes,
Okay, so that's additional to the other emission.
yes.
Thank you.
Right, so we have, this is an overall view of most of the facility operations inside the enclosure building. So to give you a little perspective, back here we have the grid casting machine that we were talking about previously. Then we have some stations set up at various points. I'm going to go back a bit. So back on this side of the building is where we just saw the lead oxide and application process. So we have a few stations here where we've got pasted grids, which are plates. They're stacked at these tables. This is another processing step here. We've got post burning, so there's some small parts that are used as we put these pasted grids or plates together, and you're burning the posts in groups together. You have workers doing that manually here, and just general assembly. So this is the three process application that was submitted. I think it was described in the order.
Is that it?
Yes?
Okay, thank you very much.
Oh, wait, I'm sorry, well, for that slide.
Oh, I'm sorry.
I was just waiting for questions, okay. Here's our bag house. So here we show the enclosure building here. When a truck drops off lead oxide, it's offloaded here and goes back here, and there's a silo over here. This is the existing Pangbourne bag house that's venting some of these processes. Right, so we have just another.
Madam Chair, I'm sorry.
Yes, do you have another question about?
There is where, then it vents into the atmosphere, is that correct?
Pardon me?
You said venting, it vents into the atmosphere out of the bag house?
Well, after, yes, the equipment from inside the building, there's certain devices
Yeah.
that vent to this bag house, and then we have, this is where it vents.
Any emission exit from the bag house?
Yes, there could
You
be
have
emissions
filters?
from there, whatever's not controlled by the bag house system.
To what extent is control at that point?
Do you know the control efficiency of the bag house? The bag house is control equipment.
I understand, right.
Right.
Do you happen, we have the engineer who can speak to that, but do you happen to know the control efficiency of the bag house?
There was a source test completed, but it was determined the source test was not adequate. So I wouldn't want to rely on those numbers. I can say that the initial loading to the inlet was very low, and that made it a little bit difficult to determine the exact control efficiency. But yeah, I'm not sure I could give a precise number on that just based on the
We'll
inaccuracy
wait
of
for the engineer
Yep.
to speak to the control equipment.
Let me stop there, because now we're getting into questions that we should probably
Right,
wait
it's
and
not
ask.
about the photo.
About the photos.
Okay.
Is questions for now.
Okay. Did I speak to this? Okay. So here we are. This is another view of the bag house we were just discussing, and which vents the existing bag house vents some of the process, the grid caster, the melting pot, the small parts casting, all vent to this bag house system. And then we have some components here. We've got a blower, some casing for a HEPA system that's going in, and then another part of the new Donaldson Torrent bag house that is planned to be installed and which has an application in.
Okay, thank you. Now we've reached the end. Did you review the violations as listed in the order for abatement?
Yes.
And do you agree, as the primary compliance officer for this facility, that those are in fact the violations at issue in this case.
Yes.
Is it true that we don't, you have not cited the facility for any kind of emissions violation, primarily because we don't have any monitors at the site to determine whether the rule limit has been exceeded?
Yes.
Have you reviewed the terms of the order for abatement that's proposed to the hearing board today?
Yes.
And did you note the curtailment provision in that order?
Yes.
The curtailment provision requires that the facility cease its lead operations if, once the monitors are installed, they exceed 0.1 micrograms per, I can never remember the unit of measure.
Micrograms a meter cubed.
Micrograms per meter cubed, thank you very much. Is that 0.1 the current rule limit in 1420.2?
Not yet.
Right.
Yeah, it's coming up in April, yes.
In fact, that level of emissions becomes enforceable on April 1st, isn't that true?
True.
Okay. You are listed as as the receiver for progress reports that the respondent has agreed to submit to document their progress during the course of the order for abatement. Are you willing to take on this task?
Yes.
Okay, just making sure. I have no further questions for the inspector, if the hearing board does.
Thank you. Mr. Williamson, do you have any questions for Ms. Bolander?
I do not.
Okay. I have, unless anybody has questions first.
I do.
Okay, Mr. Camarena.
In the petition, at page 6, line 3, it talks about a violation of Rule 1407D2. Is the respondent in violation of that at this point?
Same page.
This is in the petition, not the
Oh, the
findings.
petition. Okay.
It's right here.
Yes. Yes.
Can you tell me what part or parts of 1407 are being violated?
It was the source testing requirement for having the source testing done on the control equipment.
Is that the only part?
Yes.
Okay. In one of your slides, you showed a portion of the operation that is to be vented to a baghouse or an air pollution control device. Did I read it right?
Yes.
Okay. Now, 1407D1 requires that all points be vented to an air pollution device. So are they also in violation of that?
I believe we were covering that one under the new 1420.2 regulation.
So 1407D1 does not apply?
Oh, D1. Right. It does look, it does appear that it applies. I'd like to review again the definition of emission point, whether that did include those points there, but I do believe it applies.
It says all emission points, and
Right.
that rule was in place since when?
Quite some time, 1994.
1994, and it became effective for this part in 1996.
Yes, yes,
So respondent has been in violation of D1 since 1996?
right. There was, They have been yes, they have been in violation of D1 as well, and there was a previous notice of violation issued for that.
What became of that notice of violation?
It is mentioned in the petition.
I don't know if that one is.
Pardon me?
I don't know if that one is.
So is there any exception in the rules that would relieve the respondent from compliance with D1 of 1407?
Oh, yeah, I see, it was attached as Exhibit 1.
I'm sorry, Mr. Camarena, could you repeat your question, please?
Sure. Is there any exception anywhere in the district rules that would accept any provision anywhere in the district rules that would exempt respondent from compliance with 1407 D1 at any time prior to 2015?
Not that I know of.
Thank you. I have another, well, I do have some other questions. You showed a photograph of a truck delivering lead oxide to the facility. How was that transfer made?
Oh, actually, that truck was just parked there, but I was.
That wasn't,
I was, since I didn't have the photo of the storage silo, I had noticed that the port where it's delivered to was at that point. So I don't believe I've seen a delivery to the facility of the offloading of the lead oxide to the port, but I'm hoping it wouldn't be in a truck like that. That wouldn't, so, yes,
I do have a few more questions.
sure.
When was respondent required to begin monitoring?
The monitor is required 90 days after the approval of your plan, I believe. He just says he doesn't have an approved plan.
And when were they required to have an approved plan?
Well, let me double check on that date. Okay. Okay. He submitted a plan for review. It was eventually denied.
When was that?
Actually, that's an engine, I don't have that date. I believe Mr. Gabriel does have that date,
Okay.
since he was in charge of the monitoring plan.
Okay, I think I have just one more question. Prior to 2015, are you aware of any inspection or notice of violation issued to respondent for violation of Rule 1407?
There was one, what was the date on this? Oh, I don't know.
I have no other questions.
Senator, yes?
What rule is that?
1407.
1407? Thank you.
Did anybody review, just back on that, the last question by Mr. Camarena, did anybody review the record for NOVs or of inspections for this facility prior to the hearing today?
Yes.
Okay. So, is that what you're looking at right now?
I am. So you're asking, would you
The
like?
question was whether or not there had been any previous NOVs? Was that the question, Mr. Camarena?
Yes.
Okay.
Do you have that information?
So there was,
I got the rule. Compliance.
so there was an NOV issued, the violation, let's see, they actually issued in November 5th, 2015. And that was for 203, 1420, 1407.
And
Yeah.
that NOV is attached to the petition as Exhibit 1.
So is there, on the review and what you have there of the facility, other than the 2 NOVs that are attached to the petition, were there any others?
Last one I saw, I believe, was in 2001.
And do you recall what that was for?
I do not. I'd have to go back and research that.
Okay. Perhaps you can do that on a
Sure.
break, or
Sure.
that
So,
would be helpful.
okay.
So I guess my first question had been, which of the violations, because I was looking at Exhibit 1 to the petition, the notice of violation that has a date of violation in 2015, and my question had been, which rules was that? But I think you answered that question. That was Rule 203, 1420, and 1407, is that correct?
Yes.
Okay. I don't know if this is a question for you or if it will be for the engineer when we have that person to ask questions, but in her opening, Ms. Feldman had mentioned that for some reason, based on your knowledge of the facility and its processes, you do not anticipate excess emissions. Do you have any explanation of why that is, if there are? Oh.
If I may clarify, I did not say excess emissions.
I'm sorry.
There will be excess emissions.
Okay.
In my opening, I said we did not believe that there would be excess lead emissions that would exceed the rule limit.
Okay. So with that, thank you for that clarification. With that clarification, excess lead emissions that would exceed the rule limit, do you have any explanation of why you do not anticipate that, given the fact that there are some currently unpermitted processes and equipment, and also there is equipment that is not currently vented to a baghouse that meets the...
I think the fact that the operations are taking place in a total enclosure, and that there's some very elaborate housekeeping practices in place, including sweeping the yard and inside the building. Should hopefully control lead that could impact the monitors.
I'm sorry, can you repeat that last part? So the total enclosure, and then,
Total enclosure exists, I should probably add that there is some control, the baghouse system, and just the housekeeping practices.
housekeeping practices
Yeah,
currently,
both
for fugitive or
For
excess?
fugitive, the 1420.2 housekeeping practices are pretty elaborate, detailed, and housekeeping both within the building and in the yard outside the building are in place.
But you have no, because there are no monitors, you have no starting point or ability to know even how close they are to the limit currently. You just really have no way of knowing that.
Yes, that's correct.
Okay. I see that, I was passed this by Mr. Camarino, I believe, that in Find, that there's information on the NOV from 2001. So if I could, I think I would put this in as an exhibit from the hearing board. So I'm going to, on a break, ask if we can have copies made of that, and I can allow Mr. Camarina to put it in, but we'll put it in as exhibit, board exhibit number 1. I don't think I have any other questions for the 0.1 nanogram per meter cube lead standard. So that doesn't go into effect until April?
The 0.1 microgram? Per
Microgram,
cubic-
did I say that
right.
wrong? Sorry, microgram.
Per cubic meters, that's not till April.
Until April. April, what was the date?
It's April 1st.
Okay. So under, well, what is the current standard, do you know?
It's 0.15 micrograms per cubic meter.
Okay. Thank you. Does
I have
anyone
one
else
more question.
Mr. Camarena has another question.
The operations that were shown that were to be vented, not vented yet,
Correct.
do you know when they were installed?
Those have always been there as part of the process.
Since?
I
You don't know? Okay.
That might be
We'll-
better
we'll
asked the
ask- We'll
respondent.
ask the respondent.
Ms. Byrd?
Just to follow up a little bit, and what we saw in your presentation was a manual assembly of those parts. There is nothing other than that manual assembly. After those things are produced, they're just manually assembled. There were some gentlemen there, and I got, from the picture, I got the impression that they were now taking
That's
the parts.
probably another question that
Okay.
respondent can address for you.
Okay, thanks.
Does anyone else, any other board members have questions for this witness, for Ms. Bolander? Okay, seeing none. Ms. Feldman, your next witness.
Thank you. You're excused. Thank you very much. The district will call Nabil Gabriel.
Before you begin, we are now, thank you, Madam Clerk. We have now received a copy from the AQMD's fined facility information detail with regard to this facility and a notice of violation on May 24, 2001, and we're going to mark that as Hearing Board Exhibit Number 1. You may proceed.
Thank you.
Yes, hearing board number 1, as opposed to if there's any, bless you, if there's anything from the district.
Would you please state your name and spell it for the record? Make sure your microphone is on and speak directly into it.
Good morning. My name is Nabil Gabriel, Gobrial.
Could you spell your first name too?
Nabil, Nabil.
Thank you. What is your position with the district?
Senior Air Quality Engineer.
And how long have you held that position?
I've been in this position for a year, and I've been with the engineering division for almost 30 years.
I'm sorry,
I've been with the engineering division for 30 years, and I've been as a senior engineer for 1 year.
okay. And did you take the oath this morning?
Yes, I did.
Okay, thank you. Let's start with the questions that the hearing board had about the lead monitoring plan that was submitted by the respondent. Are you familiar with that plan?
Yes, I am.
And was it timely submitted? The rule requires submission in 2016. Did that happen?
Yes, he did submit it on March.
Right in the mic.
He did, the respondent submit the plan application on March 16, 2016, and the application was denied on February 2018.
So it was just denied recently?
Yes.
What took so long?
We're trying to get the respondent to compliance with the rule because the plan was submitted with a source test. It was not approved by the lab. It's not on the listing for the lab approval. And he didn't put any monitors, so we did deny it because also some of the equipment was not vented to a control equipment bill requirement of 1420.2.
Okay, so let's back up a little bit. Is it your impression that when respondents submitted the monitoring plan, the yeah, the monitoring plan, it was his belief that he did not have to place monitors at the facility?
No, it was he believed that he had to put the monitoring, but he did not submit the plan according to 1420.2.
Okay. And then, as it turned out, the source test was also disapproved by the district source testing team, is that correct?
Yes, that's correct.
Okay. And what happened? So that's a lengthy process where source testing disapproves a plan. Was another source test ultimately conducted?
No,
And is that why source testing is part of the order for abatement?
yes,
Okay. Have you had an opportunity to review this order for abatement?
yes,
You'll see in there that it refers to several pending applications. One is, and the inspector did refer to this in her PowerPoint, for the installation of a new bag house. Could you please explain to the hearing board what that new bag house will do?
The bag house, it will control the emission from the point source, and it's going to be determined by a source test.
And did you watch the PowerPoint presentation as it was presented?
No, it wasn't showing in the back here.
Oh, I'm so sorry, it wasn't on the main monitor, that's right. Okay, but you listened to Ms. Bollander's description of the part of the operation that will be controlled by the new bag house.
Yes,
Did you concur with that description?
yes.
Okay, and what is the status of that permit application?
It is under review.
Okay, and do you anticipate that that permit will be issued in a relatively short period of time?
Yes.
Do you have a date in mind?
By the next week, by the end of the next week.
Okay. Now, there's also a permit application that relates to the existing bag house, is that correct?
We did not receive the application for the existing bag house for modification, and that's the one we're waiting for now.
Okay, and that measure is addressed in the proposed order for abatement, isn't it?
Yes,
So that will require the submission of an application, to the best of your understanding?
yes.
Okay. And why does that existing bag house require a permit application?
Because this bag house will be venting only a couple of pieces of equipment, and a new bag house will be venting most of the equipment. So we need to modify what is the bag house. First of all, to comply with 1420.2 because it does not meet 1420.2. And I think the respondents say he's going to put a HEPA filter on the top of the bag house to comply with 1420.2. And we issue the permit for the newer bag house for the other equipment.
Okay, so it's not that this bag house, this existing bag house, is operating without a permit. It's that the permit it's operating under needs to be modified. Is that a fair assessment?
Yes,
Okay. There's a third permit application that relates to the silo. Ms. Bollander described the silo as a storage unit for lead oxide. Is that a correct assessment?
yes,
And why does this silo need a permit?
because it wasn't permitted. One of the sources is not permitted yet.
Okay, so it's also a source of emissions?
Yes.
Okay. And have you received an application for that?
Yes,
And when was that submitted?
in 2017.
Okay, do you have a month?
Yes, we can do. Okay, in August 2017.
Okay. And what is the status of that application?
It's still pending because this equipment's supposed to be venting to the new bag house. If I don't have the bag house permit, I cannot permit this one.
Okay. Did we have any concerns about compliance with Rule 212 at this facility?
No.
Okay.
Can you clarify Rule 212 so that we know what?
Yes,
what that means?
rather than me testifying, would you explain to the hearing board what the requirements of Rule 212 are?
212 require public notice if there is a school within 1,000 feet.
Okay. There is another permit cited in the order for abatement for a three-way process. Could you just describe in very general terms for the hearing board what this three-way process is?
Okay, sure. The three-way process, it is the plate stacking and post and group burning to put it on the assembly case. And I did receive an application for this one last week.
Okay. And perhaps we could have the respondent describe in greater detail why it's even called a three-way process. We believe, though, that that's a lead point source?
Yes,
Okay. And we did receive a permit application?
yes,
So but just last week, so I assume that that's still under review?
yes.
Okay. Do you anticipate any problems so far, based on your review with the issuance of this permit?
No.
Okay. And finally, did you receive yet another permit application that I don't believe is addressed because it was so recently submitted for a vacuum system at this facility?
Yes.
And how is that different than the vacuum they're using now?
This unit, he told us that he has a central vacuum system which is require permit, and therefore he did submit an application on February 22nd, 2018.
Okay, so this is going to be for a centralized vacuum system as opposed to the vacuum, like the standalone vacuum that's referenced in the order for abatement?
Yes,
Okay. Does he still need a permit for that standalone vacuum that's referenced in the order?
we've been talking to the enforcement compliance people, and if it is wet, it does not require permit. If it is dry, yes, it does require permit.
Okay, we can clarify that then with the respondent. I have no further questions for the engineer.
Thank you, Mr. Williamson. Do you have any questions?
I do not.
Board members? I do. Oh,
Could you please run by, I was trying to take notes while you were talking, and I don't think I was very successful. The old bag house needs a permit to function, is that correct?
That's correct, because it is not in compliance with 1420.2 at that time.
Okay, and you said that they were going to put a HEPA filter on it?
Yes,
And
that's
then that will be part of the application?
yes,
And then you will source test that at that site?
of course, yes.
Is that correct?
Yes, correct.
Okay. In the bag houses, I just want to be sure for my own information, the bag house is merely a storage place for materials that are being removed in the process of making the batteries, is that correct?
It's not a storage, the bag house is a control receiving the emission from the other source or point of source and control the emission with 90%, 95%, whatever it is, and whatever left is gonna go to the,
I see, okay, fine, thank you, that's very helpful.
Mr. Camarena?
Thank you. Mr. Gabriel, I didn't get all the dates on the monitoring. As I understand it, the monitoring was due to be done 90 days after approval of the plan, and you told us that a plan was submitted in a timely fashion?
yes.
Okay. And then it was, and when was that?
The plan was submitted on March 2016.
March 2015 or 16?
16.
16,
The rule was adopted on 2015.
right. And then it was denied on February of,
2018.
okay. Now, okay, that's just a few weeks ago.
Yes.
Is there a time frame in the rule that requires resubmittal?
Yeah, there it was, the submittal was December 2015. It has to be submitted to the district.
Right, that's the original one, but if it's denied, rejected, is there a time frame during which a new revised plan has to be submitted?
We have contacted the respondent, and he supposed to send an application for 1420.2 plan.
Does the rule specify a time frame for,
Not as I remember, no.
And since that is a legal question, I feel comfortable addressing that. There is no specification in the rule for resubmittal of a plan upon denial.
okay. So absent an order from this board, there would be no requirement. With respect to the source test, that plan was submitted, or the protocol was submitted when?
It was submitted with the plan, and we sent it to source test for review, and the respondent was informed that the test is not good. It's not in compliance with the rule.
When was that?
Sometime on 2016, late 2016.
I have to correct myself here. I missed that provision in the rule. 1420.2 E 1D, two little i's. I never know how to refer to that, if it's just another two or two little i's, says that if the lead ambient air monitoring and sampling plan is disapproved, the owner or operator shall resubmit the plan within 30 days.
30 days, okay, so he has 30 days from sometime in February.
Yes, from 2/13, he have another week and a half to submit it, yes.
Okay. Thank you very much.
Welcome, sir.
I'm sorry, so the facility has 30 days under the rule to resubmit from February. Do you have the exact day in February?
February 13.
February 13th, which is coming up really soon. Do you know why? Am I understanding this to be a different plan, or can you explain? I'm looking on,
No, it
in
is.
the order, in the order, on page 9, number 6, that respondent shall, within 10 days of receiving final source test reports for the existing and new bag houses, submit a lead ambient air monitoring and sampling plan sufficient for approval. Is that different from the plan that was denied?
Well, the plan denied for a reason, which is that source test was not in compliance. And the new plan, he's gonna repeat the test with approved source testing firm.
But the facility will additionally be in violation, well, maybe you can't answer this question, but it appears that the facility will be further violation of the rule, when March, what have you, comes, and there is no resubmission of the plan.
You are correct in that assessment, Ms. Prusak. The problem is that the plan really can't be submitted in any meaningful way without the source test results.
Which the facility knew about, as you just testified to, knew that it was rejected, the source test results were rejected at the end of 2016. Is that correct?
Yes.
I also wasn't sure I understood this correctly, but did you say that under the rule, the plan was originally due December 2015? No? Yes?
Yes.
Okay. So when it was submitted March of 2016, that was late? No?
No, the rule was adopted
Okay.
in December of 2015.
Thank you. All right, I was understanding that
Plan was
wrong.
due in March of 2016.
Gotcha, so it was on time.
Yes.
Okay. Do you know how much more efficient, the new bag house that is, they're seeking a permit for, than the existing bag house?
That's what we're trying to find out with the source test, but it should be more than the 99%.
The new bag house?
And the old bag house too, because Rule 1420.2 requires that efficiency more than 99%.
But the problem is you don't know what the efficiency is currently of the existing bag house because the source test was not correctly done?
That's correct.
Okay. Do you have, I asked the previous witness, Ms. Bolander, why her opinion on why excess emissions above the current limit for lead are not anticipated from this facility. Do you have an opinion as to why or why not?
I cannot judge that because I don't know what is the efficiency for the bag houses, both bag houses, the old one and the new one.
Okay, so you cannot make that decision or make that, or you can't form that opinion. And what about the fact that there are pieces of equipment that are not currently being vented to a bag house? Would that factor into your ability to make an opinion as to whether or not this facility is possibly over the lead limit?
Well, are you talking about the lead limit of 0.1 microgram per cubic feet?
Or the current of 0.15?
I cannot determine because it is based on the source test results.
Okay. I have a question. I'm looking also at the order on page 9. The very first condition is a visual integrity test of something called the lead furnace crucible. Can you explain, if you know, what that is and why this?
That's actually page 6. I believe you said page 9.
I'm so sorry. I'm obviously dyslexic
9,
upside
6.
down. And I need reading glasses. Okay, sorry, page 6, the very first condition of the order. My question's, sorry, it's compound, but what is the lead furnace crucible? And if you know, why does it require a visual integrity test at this point?
This question came from a compliance division to find out the integrity of the furnace, if it is leaking or not, and they have to do the test before they start.
Do you know whether there's a concern that it is leaking?
No, that's mostly is a compliance question.
Okay, so your answer no was that you know that there is not a concern currently?
Yes.
Okay. Okay, and then finally, I just wanted to go over on page 8. I know this is an 8. Even upside down, it's an 8. Condition number 3 with regard to permit applications. The first one, little I, the 3-process operation, that one you just testified you have already received the application.
That's correct.
So we don't need that in there, is that correct?
Yes.
Okay. But you did also testify that the modification to the existing bag house, that has not yet been
I
submitted?
have not received yet.
Okay, and then the vacuum as well, you have not yet received
No,
that?
the vacuum is received already.
It is received.
Let me clarify that. Do you have a permit application for the centralized new vacuum system?
Yes.
But do you have a permit application for the standalone vacuum that they presently use?
No.
Right, and that's what that refers to. It's not the centralized system.
Okay, and is that, in your mind, is that clear enough when it says a vacuum which complies with Rule 1420.1H1, that refers to the existing vacuum system for which there is not a permit?
I think they're talking about the portable vacuum, which is the dry one.
Okay, so would it be helpful to state either the portable vacuum or the current portable vacuum, or something else that would clarify this?
Yes.
Okay. And then, one other question, and then I'll ask if anyone else has questions. But the very next condition, new equipment with regard to the new bag house, in your opinion, if the bag house is already on site, do you know if 60 days is what generally it takes to install a bag house like this?
It depends on the manpower, but I think it can be installed, yes.
Okay, so that's a reasonable estimate. Okay. Anyone else? Ms. Burt?
I just had a follow-up question because I wasn't sure if I heard correctly. Was the reason for the denial of the source test, for some reason, I thought I heard it said that it was because the source test firm was the reason?
It was not approved, yes.
It was not approved. That was the only reason it was. Okay. Okay, I thought that's what I heard. And then the silo that the application's already in, but you can't approve it until the back house is approved. How long would that take afterwards, since you already have it?
Well, since after he constructs the bag house, I can give him a permit to construct. I can issue a permit to construct for the bag house and the other equipment, and then he start testing and contract the source testing for the two bag house, and then we can respond to the 1420.2 ambient air monitoring plan. So I can approve the permit to construct for 4 pieces out of the 5 application I have, because the 5th one is already in operation, and I cannot issue a permit to construct. It have to be a permit to operate.
Okay. I'm sorry, and time-wise, I guess is what I was trying to follow, the silo after that was issued.
Well, maybe the following week, not next week, the
So it'll
following
only take a week? Oh, okay. All right, thank you.
Mr. Camarena?
Regarding the source test plan, does the rule require that the protocol and the test be done by an approved, district-approved source test firm?
Yes,
And they used a non-approved source test firm?
yes.
And that protocol was filed along with the monitoring plan in 2016?
That's correct.
Have they filed a new protocol?
No,
Does the rule require, same question as with the air monitoring, after disapproval of a protocol, does the rule require a resubmittal?
well, because the source test is under the plan, so if the plan is denied, he have to submit another one for 30 days.
So that requires 30 days.
Yes,
And
from the
let's
denial of the plan.
say 2016, 2017, it's more than 30 days, isn't it?
No, I did say from the denial of the plan. The
Okay.
plan was denied February 13. He have 30 days to submit a plan with the source test within a week or within 13 days.
I'm confused. Let me ask it
Sure.
a little simpler. Are they overdue on submittal of a protocol for source testing?
Well, because we were evaluating the plan, and the plan was denied, and the plan require a source test. So he's now due for the source test because the plan is denied.
This is a little
As-
complicated. Maybe
no,
Ms. Feldman can help.
Yes. The rule requires resubmittal of a plan, an amended plan, within 30 days after the district disapproves the first plan. Part of the plan is the protocol for the source, any source testing that needs to be done. Because the district only disapproved this plan on February 13th of this year. Respondent has until
Sometime in
March
March.
13th
Okay,
to submit a new protocol.
thank you.
I had a quick follow-up question. It's probably straightforward, but I'm not an engineer. Lead emissions through the bag house system, is it all linear, meaning it's dependent upon throughput? So if there's more activity or more work being done on the process, there's more lead emissions, and if there's curtailment of the process, there would be fewer?
Yes.
Okay. I thought that was, but I just wanted to make sure. Anyone else have questions? Senator?
To your knowledge, how long has this company been in operation?
How is this company?
How long?
How long? How long is the company in operation?
Been in business, yeah.
I think for more than 20 years.
More than 20 years. And for most of those 20 years, they've been violating the emission standards.
Not
Yes
the,
or no?
there's no evidence before you that says they violated the emissions standards, Senator. They violated rule requirements, not an emission limit.
The rule requirements, to what extent?
As noted in the notices of violation that are attached to the petition.
Those violations came just within the past couple of years.
Right.
So prior to that, they were involved.
There was one in 2001 as well. That's part of your own exhibit.
That is Hearing Board Exhibit 1.
Right. Now, here's my concern. Lead poisoning is toxic.
There's no evidence of an
I
emissions
understand.
violation, Senator.
I'm just saying, making a statement. I'm not saying they violated it or they didn't violate it. I'm making a statement as I understand it to be. But it was testified that the closest resident was about 1,200 feet away, close to a quarter of a mile, whatever that means. So all these years of operation, one could speculate or almost assume that the emission was going that direction, even though this not before us today on emission violation.
Just let me stop you there and then ask the question, but we cannot assume that. We can take the evidence and we can make logical conclusions from the evidence, but other than that, we cannot speculate, just to make that clarification.
Logical conclusion, is that a speculation?
We can talk in deliberation,
I'm just saying, yeah, but
and you
that's-
can ask the question.
Logical conclusion is a speculation, I would think. So what I'm really saying is that they've been operating for 20 years, and lead poisoning we know is very toxic. Now, you cannot consider citing or specifying that they've stating they've exceeded a certain limit because you don't know what that is. I understand that. Until you get those monitoring devices in place, which is part of the stipulation order. In the stipulation order, you also specify certain dates at which time these corrective actions are to be taken. And there's any way of plan to try and understand whether or not those dates are being met collectively. I mean, checking on, because sometimes they're delayed for various reasons. And if they are delayed or could be delayed, any way of determining that delay, that they are delaying it, and what corrective action will be taken at that time.
Is that a question, Senator?
Yeah.
First of all, we, just for clarity, we would adopt or grant an order for abatement. It is the district's role to enforce it. And my understanding would be that the district would enforce it. But I don't know that this isn't, we have right now an engineer on as a witness, so I'm not sure if that is an appropriate question for the witness, but any violation of this order for abatement, should we grant it and adopt it, would be a violation, is considered a violation of district rules.
That's understood, clearly understood. it just so happens that there's a, and we've asked this question on other matters that came before the board, what should happen when you don't meet the deadline? And they've been able to respond to that. Now, maybe in this case, they're not. I don't know. I just raised the question because it's not out of order.
Again, this witness, I can ask the witness, can you respond to that? Because this witness is not in enforcement. This witness is in engineering.
Compliance division, and I cannot respond to this question.
Could you, I'm sorry, can you just answer that in the
I am not
microphone.
in compliance division, and I cannot answer this question.
So it's appropriate for compliance. Okay. Good answer.
But the answer would definitely be they would be in violation, and there is no wiggle room once an order is granted by this board.
Right. Inside the plant where all this work is being taken place, I believe I saw some covering of the employees seemed to have something on their face. Couldn't determine that was for protection or not.
I think that would be a good question for the respondent.
That was a good question for the inspector when I had to look.
The
They-
inspector was on and has been dismissed. This is the engineer.
I know
He's
you-
not been to the facility.
I'm not asking the engineer. The inspector has not been dismissed. They're sitting there waiting to be called again if necessary.
If necessary.
Okay, but right now we have the engineer on.
I understand.
Wait, Senator. If you want to, after we're done with the engineer, if you'd like to recall for an important question to make your decision, the inspector, we can do so. But for now, do you have any questions for the
I look
engineer?
forward to that. No other questions at this point.
Okay. Anyone else have any questions for the engineer? Okay, seeing none, I believe the senator would like to ask Ms. Bolander additional questions. So did you have any other witnesses after this?
No, thank you.
Okay, I didn't think so. So right before we take our break at around 10:30, why don't we
be
finish
fine.
that up?
Thank you so much. Senator, if you'd like to re-ask your questions, we have Ms. Bolander here. Ms. Bolander, you understand you're still under oath?
Yes.
Thank you.
I think that, did you hear my question before? Should I repeat it?
I think it would be clearer for the record if you did repeat it. Thank you.
Fine, I was concerned about emissions inside the facility and whether or not the employees had any protective devices at the time they were performing their operation.
I did see workers wearing respirators, but I cannot testify to what the purpose. Obviously, it was to to protect their lungs,
Lungs.
right? But I can't testify further than that. Other than I saw workers wearing them.
For protection,
That's
in your
yes,
view.
in my view.
Did you notice, or for whatever reason seem to take notice, whether or not any OSHA requirements were posted on the walls around there?
I did not notice.
So do you know whether or not there was any OSHA requirements requested?
I can't answer that question.
I'm going to allow a couple more questions on this, but just, Senator, just please keep in mind, while I know you are concerned for the workers, as we all are, the OSHA requirements are not at all
I mean,
relevant to today's hearing.
no, we think about the efficiency of the equipment that's in operation and whether or not there's any leaks, which has not yet been determined. So that's why I asked the question. So if there had been tested and verified by OSHA that they have no major problem, fine. Otherwise, there is something to be considered with the existing equipment in operation, which no matter what you do outside in terms of making these other corrections, you have some leaks
Just to
Actually,
clarify the record.
sorry, excuse me, sorry. I will clarify the record. The question was asked by myself and clarified that there actually are no current concerns that there are leaks. The visual inspection test that I was questioning is merely a matter of something that is required, but there is no concern currently that there are leaks.
Is it
That's a matter of the record.
visual testing? What do you mean by that?
Senator, it's one of the proposed conditions of the proposed stipulated order for abatement. It would be condition number 1.
And that's something that you can see if there's a problem?
I'll just read it into the record again. The order proposes as condition number 1, visual integrity tests. Respondent shall, within 3 days of the issuance of this order, perform a visual integrity test on the lead furnace crucible for the purpose of ensuring it is free from defects and is in proper working condition. I asked the question, what is the lead furnace crucible, and is there any current concern that it does have leaks? And the answer was no, there is no concern, but merely that is a requirement of a rule, and it's for compliance purposes.
Well, I see what they put in that order, but actually, it's not visible. You have to have a device in order to measure the effectiveness of the equipment by using a device.
This is a visual integrity test, and it is visible. Visible.
Not to my knowledge, you carry on. I have no further questions.
Dr. Lerner has a question.
Yeah. When you were showing us the original area, the geographic area where the factory is located, are there any other battery companies in that area?
Not that I know of.
I see, okay. I'm just thinking about other sources of lead in the air and the confusion that we've all experienced dealing with problems of odor and pollution, other kinds of pollution. Thank you.
Any other questions for Ms. Bolander? Mr. Camarena?
Are we going to take a break soon?
We
Okay.
are going to right after this.
I'd like to make reference to Hearing Board Exhibit 1, and perhaps the district may look into it. If you'll notice under follow-up status, it says in compliance. So my question is, the operations that were shown on the slide that are yet to be controlled, were they in operation at that time or at any time before 2015?
I'm not confident we'll be able to answer that. The district's record retention policy for notices of violation is 10 years. And so we are well beyond that period of time. I can't pull a file to take a look. It is perhaps something that the respondent might be able to address, considering he's been operating this facility consistently all along.
So the question will still remain that when was that equipment in operation? And perhaps there have been some inspections within that records of which the district still has that might shed some light on that. Thank you.
Any other questions? Thank you. And just to confirm, Ms. Feldman, you have no other witnesses, is that
No
correct?
other witnesses, thank you.
Okay, so we will take a break, and we will go off the record and then reconvene at 11:15 at 10:45. And at that time, we will hear from the respondent. We are off the record. We are back on the record, and we are going to begin with the respondent. And Mr. Williamson, if you can introduce your witness and have him state, spell his name, give his title, and indicate whether he took the oath.
Certain, I had one housekeeping order before we jumped in, and I missed it when we were talking before the break. But we had discussed a correction to the proposed order on page 8, item 3I. It was the vacuum, which complies with Rule 1420.1H1.
I don't think it was on show the break. I don't think we got that on record.
We got, it started late?
No, the picture wasn't up, but the recording was
Okay, okay.
We're good?
You can, yes, you can continue, Mr. Williamson.
We had, the clarification was offered that that was a remote vacuum. The remote vacuum is actually going to be decommissioned with the centralized vacuum. And so the permit application has actually already been submitted on item 3.
Okay, the little I-3,
Yes.
and Ms. Feldman agree?
Mr. Williamson is correct. We did discuss this during the break, and it was the district's impression that the respondent intended to keep that standalone vacuum in addition to the centralized system, but we were informed that no, in fact, they're no longer going to be using that standalone vacuum, so we don't need a permit application for that.
Okay, so should we adopt the proposed order now, there would not be little i's, little I2, little 3i's. It would just merely, instead of the following equipment, it would just say for the modification to existing bag house permitted under.
Right, and if I may be permitted to rock your world for one little second, I also found out during the break that the little i's are called Romanettes.
You know you had to know the answer to that. And I'm going to try to remember that. Romanette number 2 will stay. Dr. Leonard, did you have a question on this?
Well, I was gonna comment about the Romanesque number 3, okay? And so okay, we haven't decided on that, but right now, because I put here standalone vacuum, so this is just gonna be the new one.
Yes.
Okay, fine.
The new-
Okay, so we can change that to make that more precise when we get around to doing the order. Okay, thank you.
Yes.
Thank you for that clarification, Mr. Williamson. You may proceed.
No problem. Mr. Sloan, you took your, the oath earlier this morning, and you understand that you are still under oath?
I do.
Can you state and spell your name for the record, please?
My name is Derek Sloan, DEREK SLOAN. I am the president of Industrial Battery Engineering.
And if we can, it may be helpful to borrow the demonstrative exhibit that the district used to talk through. Mr. Sloan, I was hoping you could walk us through the process that your facility goes through in manufacturing these forklift batteries. Do we still have the?
Just for clarification for the record, we did not receive hard copies of the presentation, so that was not marked as a demonstrative exhibit. So we will refer to it as the PowerPoint presentation of the district. Just for clarification.
I'm sorry, I thought we did that at break.
If you could give us a moment to plug it in and get it going.
We're off the record. Oop, we're back on the record.
Okay, I will start over with the question. We'll start with slide 1. Mr. Sloan, can you describe the location of your facility and the surrounding industrial use?
Yeah, currently we're located in an area that has quarries, rock crushing facilities, refuse transfer stations, scrap yards. If you need a part for your car, this is the place to get it. It's a highly industrial area, and we've been at the facility since the mid-60s.
And then we'll go down to slide 3, I think would be helpful for the board. Mr. Sloan, can you walk through, and again, I know we had compliance and engineering talk through in general terms about the process that occurred at your facility, but with the, keeping in mind that the board has a high overview, can you offer some more detail about the manufacturing process that your company undertakes?
Kim presented it very well earlier. We purchased lead ingots from an outside source. We melt those in a small lead pot, approximately 2,000 pounds. And then from there, it's pumped up to that small grid casting machine. We have one of those also. And we hand pour parts for our operation as well, posts, for example. Those operations are all vented to the existing bag house, and that was part of the NOV in 2001 that we were speaking of. The reason that we did get that bag house installed is a result of the 1107, and in that area there is some arsenic. We've never tested for it, but 1107 triggered that area to be vented. The other parts of it is the lead oxide silo, lead oxide blending, pasting, and plate drying, and the 3-process operation. The lead oxide silo receives shipments once a month approximately, and then we end up doing the operation for lead oxide blending, pasting, approximately 1 or 2 days a month, and that's it. We get enough stock during that time that we're able to operate for the rest of the time. From there, everything is a hand operation. The materials that come out of the pasting operation consist of hand wrapping these plates, hand stacking the plates, and welding the plates together to form a group. Once again, it's all hand operations at this point. Previously, it was our understanding that those were exempt from venting because we were under 1/2 pound a day in total facility emissions. Once the new rule came out, we became aware of some of the requirements of it. That's why we have initiated venting of these operations.
Mr. Sloan, what was the basis of your belief that that process was exempt?
It's simply, if it was, Rule 1420, from my understanding, said, if your facility is less than 1/2 pound a day, you're not required to vent all emission points to a pollution control device. That was, once again, if it was less than 1/2 pound a day. Whereas in the 1407, it just said you had to vent them, period.
And did you have any discussions with the district on that point?
Yeah, on both points. On the new requirements, that's why we ended up meeting with engineering staff and submitted applications for the new bag house and acquired the new bag house.
But prior to that, as far as the exemption to the venting requirements, did you discuss that with district, and did they agree with your position that this process was exempt?
Prior to the Rule 1420.2.
Yes.
Yes. Under 1420, it was exempt.
Okay.
After we go ahead and weld each one of the plates together and form that group in that previous operation called group burning, the rectifying process that Ms. Bolander mentioned earlier, that's a process where we simply fill each individual cell with sulfuric acid, and it gets charged for approximately 4 to 5 days. And then that cell gets placed into a finished product. and ready for shipment. Finished products for forklifts, solar applications, and for aircraft handling equipment, all electric, anywhere from a battery of 500 pounds to approximately 5,000.
And have you measured the emissions coming from the equipment that is listed within the red box here that is vented to the existing bag house? And if so, what were those findings?
There was a source test, as we previously discussed, back in, I believe, the end of 2015. This is just during the transition between 1420 and 1420.2. We submitted I apologize, I don't know some of the terms, the protocol that we were going to use for for doing the source test. As far as we knew, it was approved by the district, and we didn't know that our subcontractor used a lab that wasn't approved for 1420.2. So based on those findings, the emissions from our existing old bag house, and that's where it gets crazy for me, so I apologize. It is 0.00003 pounds per hour from our existing bag house that vents a lead pot at grid casting and small parts casting. So it's 0.403.
And have you, same question, but for the equipment in the purple box, the equipment that is to vent to the new bag house?
For the equipment that's venting to the new bag house, there was some ancient source tests that were completed by the district, I believe back in the mid-80s for it. And once again, that's how we ended up determining that we were in compliance with Rule 1420. So that was very low at that point by the districts.
Thank you. So revisiting a topic that you just brought up briefly and that we heard previously testimony on is the issue of the source test protocol being submitted to the district and subsequent issues faced with approval of the source testing that you submitted. Can you walk through that the process of the source testing on the existing bag house and clarify if any of the dates that you're talking about are different than what previous testimony reflected?
Well, once again, the source test, I believe, was done first part of, actually I have a copy here, November of 2015. And I thought the source test was fine and it was approved, but I didn't know that it wasn't acceptable to the district until I believe around July of 2017 when I came and met with the district here to try and meet with engineering staff to figure out a path towards compliance.
So it was not late 2016 as the previous testimony indicated that you found out?
No, I believe when I came in and met with the district, I believe it was mid-2017.
And what have you done, what did you do following the the news in July of 2017 that there were issues with the source testing on the existing bag house?
That's when I submitted a new application for the new bag house and the modifications for the other equipment that I want to connect to the new bag house. My anticipation is we would be decommissioning the old bag house completely, and we'd putting in the new one and all the source testing that goes along with the new one.
So it was your belief that you wouldn't need source testing for the existing bag house as a result of that change?
Correct.
Okay. And have you read the proposed findings and decision for order of abatement?
I have.
And you've read each of the individual factual findings
Yes,
and each of the conditions included in the order?
I have.
And do you stipulate and agree to the adoption of these findings and conditions as the final outcome of this hearing?
I do.
That's all I have.
Thank you. Ms. Feldman, do you have questions for Mr. Sloan?
Yes, thank you. Not to belabor the point, but we're still concerned about your vacuum, of all things. There are housekeeping requirements in Rule 1420.2 that do require that you clean the outside
Correct.
of the facility. What kind of equipment will you be using to accomplish that?
A wet scrubber.
So it's like a wet vac?
Correct.
Is that a ride-along?
No,
of equipment to push?
it's a walk behind.
Okay. To the best of your knowledge, does that require a permit?
From what I understand, and it was mentioned earlier, because it is a wet vac, it does not require a permit.
Okay, thank you.
Is that all your questions, Ms. Feldman?
That's it.
Okay. Mr. Camarena?
Thank you. Mr. Sloan, I just want to make sure I understand. The plan that we've been talking about, it has two components. One is the air monitoring, the other is source testing. And the plan, the package of the two components, was disapproved in late 2017, not 2016. Did I understand that correctly?
I don't believe so, sir. If you're talking about the ambient air monitoring plan,
Well, the way I understood it is the district was disapproving a plan which has two parts,
correct,
air monitoring, source testing.
correct.
And earlier we heard that the plan with those two parts, at least that's the way I understood it, was disapproved in 2016.
No, sir. My understanding is the monitoring plan portion of it was disapproved February, I believe, 13th approximately of this year,
okay.
of this month. That was the monitoring portion of the plan. That was the ambient air monitoring plan. And I was notified that the source test didn't meet the district's requirements in July of 2017,
Okay.
approximately. I forgot what day I came.
So it was offered as a heads up. It was an informal communication prior to the formal denial in February 13th of this year.
Sorry, that's not testimony.
No, it's not.
Thank you.
I understand, he's an attorney. Okay, the other thing I want to clarify is, let me think about this. I want to formulate my questions properly.
I have some questions then. I may have just missed this in your presentation. The three-process operation or system, how long has that been in operation at the facility? How long have you had that in place?
Since the origin of the facility, I believe that the facility's been in operation at that location since approximately 1965.
Okay. And then your explanation as to why it is not currently vented to the bag house is a misunderstanding or an understanding that under previous 1420 or under Rule 1420, because you process under a half a pound a day, it was exempted. Is that correct?
Not quite correct.
Okay.
The three-process operation itself never had a permit prior because it was a hand operation only. There's no equipment used in that. There's no venting in that operation currently. It consists of stacking and soldering with a small hand torch. And as a result of it not having any equipment or venting, the district, we had always thought that that was just an exempt operation, period.
I see. And so when did you realize that it was not?
That part is still a bit of a conversation that we're having with the district, although what we just decided to go ahead and put an application and vent it regardless.
So when you say that's still a conversation with the district, you mean you still dispute to some extent whether or not it actually requires a permit?
That portion of it, it's become kind of a moot point for us, and we just want to permit it and get it taken care of for the district.
Okay. You mentioned, okay, so back to the timeline of the monitoring plan and the source testing and that issue. So the application was put in 2016. There was testimony that at the end of 2016, you were made aware of the subcontractor issue, and you shared testimony that that was not until July 2017. But under either scenario, can you explain, we heard testimony that having source test results that are acceptable to the district is part and parcel of considering the monitoring plan and approving it. So given that, why, since July 2017, have you made no attempt to do some other source testing or bring in a bag house and get that source tested?
The reason why we haven't pursued repeat source testing on this piece of equipment is we had a permit that we applied for the new bag house. That was going to be the one that source tested, and that would be the one that was combined into the final ambient air monitoring plan.
But that was, okay, so that was, I have to go back to the petition. That was among the three permit applications that were made and rejected by the district? Am I remembering that correctly? Go
No,
back to-
from
no?
what my recollection is, they were made but not rejected by the district. The one that was rejected by the district was the ambient air monitoring plan.
Okay, I'm just going back to. Sorry, let me just find where I'm remembering. Okay. Okay. On August 22nd, 2017, this is in the petition on page 4, this is item 21. On or about August 22nd, 2017, respondent submitted 3 applications, one of which was for the new baghouse system. Then there was a meeting, and on or about January 23rd, 2018, a permit pre-denial. So, okay, so let me start with that. August 22nd, 2017, is that when the original modification, the new baghouse application was submitted to the district, to your knowledge?
That was when it was sadly enough resubmitted. I came to the district a few weeks prior to that
Okay,
and met with the engineering staff, gave it to them. Unfortunately, there was some missing parts of it on the permit app. Your permitting department sent it back to me, and I resubmitted it in August,
okay. And then
about 3 weeks later.
January of this year, there was a permit pre-denial teleconference where you were told that would not, okay, so that you were not going to get the permit.
I wasn't going to get the permit in the way that I had requested it. The way that I additionally had requested it was with an auxiliary blower in addition to the very large blower that it has. And my plan with that was to use that auxiliary blower to be able to decommission my existing bag house. So I wasn't going to have the bag house. When they told me in January at the pre-denial conference that they would not accept the auxiliary blower, it was at that point where I withdrew my request for the auxiliary blower to get this expedited.
Okay. So it was if I can paraphrase everything that I've now gone through. So it's your testimony that it was in July 2017 that you were informed or found out that the source test was done incorrectly or had the wrong subcontractor. Is that correct?
Approximately that time period.
Okay, and then a month later in August, you attempted to apply for a permit for a new baghouse.
I did apply.
And the intent was to have a new source test for a new baghouse.
Correct.
Okay. You testified, I mean, of course, this was not a proper source test, but you testified as to the results of the source test as to those processes that are vented right now to the existing baghouse of 0.403 pounds per hour of lead. Do you know how that compares with the 1.1 microgram, am I right, of lead per cubic meter standard?
No, I don't at all. And this is at a stack, whereas the 0.1 microgram per cubic meter standard is at a fence line at an ambient air monitoring point.
Okay. Just hoping we could put that into some perspective, but not. And then I've just one other question. Do you have the capability at your facility right now to curtail your operations to any extent? And if not, if you can explain why not?
The curtailment that we're talking about in the plan is basically a total shutdown if I don't meet the numbers. At this point now,
I'm not asking for that. My question is, do you have the ability, based on your current inventory, your current load and needs, if this board were to consider requesting that you reduce your operations for a certain period of time? I just wanted to hear your thoughts on your ability of your company to do that.
currently it'd be really extremely hard for us. We have customer demands and products to be shipped out. Right now we're not extremely busy. We're not doing a lot. But it would be extremely, depending on what the board decides, curtailment actually means it'd be really difficult to achieve.
And so if you're not extremely busy right now, and do you have any current obligations, customer obligations under contract?
Yeah, many.
Okay. But are you currently under your usual process load, or, because you just based on the comment, you're not extremely busy. I'm just trying to understand what that means. And are you under your permitted limits by a good amount? Are you under your average process amount?
I believe I'm under my average process amount currently, just due to market conditions.
Okay. And the reason why, and I'm not saying this is where the board is going, but I do have a lot of concerns about the timing of when this standard would come into play, because it assumes that you'll have to await you'll have to await the permit for the new bag house. You'll have to await a source test for that new bag house. Then you'll have to await your monitoring plan, then 30 days to install the monitors, and then it relies on a 30-day rolling average for that to ever kick in, which seems like it could take a very long time. And so I just wanted to know if you have any information on lost profits, were you to, what wiggle room you might have for reducing to some percentage of your current throughput, just so that when we deliberate, we have full understanding of your process. I'm sorry. I was just explaining how it would work under the proposed conditions in terms of timing.
Target dates, target time. That's what you're talking about, I think.
Do you understand the question?
I'm trying to understand it too.
Okay. Well, let me start with the witness. Do you understand the question?
Yes, I believe I do. I believe that you're asking me, if you were to go ahead and request that I curtail my operation, what impact would that curtailment have upon me?
That's correct. And my long explanation is just to sort of put on the record my concern as to the timing as to when certain conditions will take effect under the proposed order. So in particular, I'm concerned about the timing of what I perceive to be an important provision, which is condition, sorry, I'm looking at the wrong one. Condition 2, Romanette 6 VI, which is on page 7, which has to do with if the facility exceeds a rolling 30-day average of 0.1 microgram lead per cubic meter at any monitor, the cessation of operation, and how long it might be before that occurs. So I just wanted to understand that if, as part of any order for abatement, we were to require some curtailment, I wanted to understand from the facility what hardship that would be and what percentage if you could explain.
The issue really is unfortunately, it'd be long-term devastating for us because we rely on relationships with our customers to sell our product and, meeting their needs in a timely fashion. If we're just flat closed down, we can't meet those needs, those customers unfortunately go elsewhere. And to pull them back would potentially be, a death nail for me.
Do you have a more of an explanation for what long-term means? And say if there were curtailment of, some percentage of your operations for 30 or 60 days, what the impact might be?
That's what I'm saying. Unfortunately, I can't give you a firm answer because if you're, I don't know where we're talking about the curtailment starting from. Are we talking about from my busiest peak that I was ever at, or are we talking about from today? And if we're talking about curtailment from today's operation, we're already somewhat slow, and to slow that down even more would be very, very bad.
Okay, and what about if you were to stay at your current, which is below your average? What impact do you, if you know? I mean, I know we're asking you to I'm asking you to speculate to some extent, but I do want to hear from you what the impact would be.
No, if we stayed at our current average, that would be our current average. That wouldn't be devastating.
No, the current amount you are right now, which you said is below your average.
Right.
Okay.
So if we stayed there, it'd be adequate, and we could continue on and get everything in place.
Okay. And that is well below your permitted throughput?
Correct.
Max.
Well below.
Okay, thank you, that's helpful. Sorry for that long-winded
below.
question, but that was an important one to me. Mr. Camarena, should we come back to you? Are you ready for the questions that you punted on? Okay. Anyone else have questions for the witness? Yes, Ms.
I
Berg?
just have a basic question, just to round this whole thing out some. You said that you would lose contracts, possibly, or that you have contracts that you have to fulfill. Do you have other competitors in this area that would pick up those contracts, or where would your customers go if you didn't?
We're the only one manufacturing in this area, this type of product, but our major competition is, worldwide, competitors, unfortunately. We're a very small little operation in the scheme of, our market.
When you say small, you mean profit-wise or employee-wise?
Employee-wise, we're 19 employees currently, and we're dealing with, some competitors that are multinational.
Okay. And other than potential fines from the district, would there be any financial impact losses, say, to you if you did not meet these deadlines that are in the order? If for whatever reason you could not, I do see that, well, let me back up. I do see that one of the conditions, and I can't remember which one it is, says that you have to put this equipment in whether you have to shut down or not. But I was just curious as to if there was some reason that you did not get this equipment put in and you were shut down, if it's kind of dovetailing on Ms. Prusak's question, I guess. When would you see that you could not continue operation? How long would that take, or?
If I was closed down, or I don't.
If you went over your rolling average, for instance, and you found that you were shutting down, what financial impact would that have? Would that cause a complete close of the facility?
Yeah,
Kind of what would that do?
Yeah, I have limited finished goods in inventory currently, but ballpark, about 60% or more of my product is made to order. So if I wasn't in operation, I would be in dire shape.
Okay, okay. Just trying to get an understanding of the company operation, that's all. Thank you.
Any other questions? I have one, but I'll hold it. Dr. Lerner?
I kind of got lost in this dialogue between the chairperson and yourself. If your average daily output, your average, forgetting about whether you're in or out of compliance, is, let's say, 100%, is it okay for you to tell us about what you are currently of that average? Are you 80% of that, or 60% of it, or 40%? Can you give us a ballpark idea?
If we're going back to one of my periods of time where I was really, really busy,
No, excuse me, no, I'm sorry. Please, I didn't mean to interrupt you. I'm sorry. Please continue.
No problem, sir. I'm having trouble answering the question because I'm trying to figure out where to compare it to. Back in 2008, 2009, we were much busier than we are today. We're currently at about 65% of that number, 70% of that number, versus back then.
Okay. And that was a peak, the peak, you're talking about the peak being 100%, you're 65, 70%. Okay.
Correct.
If you averaged out 2017 as 100%, considering highs and lows, so we get an average, where are you in terms of that average? If that average is 100%, where are you now, today, or last month? A ballpark idea. I just want to get my head around this.
I believe I'm on approximately the same path that I was last year, approximately,
Okay.
as 2017.
And 2017 was the number that you mentioned earlier compared to what you were before, okay, at your peak. Okay, thank you.
Yep. And by the way, I want to add that even with that peak number, I was still far below my permitted amount.
I have a question for you to consider, and you do not have to answer it right now, but a consideration. I wonder if you will consider a condition or a requirement that would have the facility staying at the current levels, not going below it, but at the current levels, which I now understand is below your average and well below your permit limit, until the new bag house is installed, which under condition 4 would be within 60 days of receipt of the permit, which I understood from testimony would be sometime, hopefully next week. So you don't have to answer that now, but for consideration, it's something that this board member is thinking about. Thank you. Does anyone else, Senator, do you have?
A question was asked of you, Mr. Sloan. What's your competition like should you cease to operate in this area? I think the answer was this, and there's no other company doing what you're doing.
I want to be clear. The competition is being shipped in from out of the area. So there's a lot of competition, and there's other avenues that my customers would go to, if that's answering your question. There's nobody here locally that's manufacturing, but there's people all, around the world and across the country that are manufacturing my product.
And they can ship it from around the world at less cost than buying it from you here?
Well, that's part of the problem that I run into is national accounts, national sales forces. I'm doing the best that I can.
I think you are. You've been in business for about 57 years, you said, since the mid-'60s. And were any regulations controlled of this operation since that time period, prior to recently?
Have any regulations been put into effect since then?
Right.
It's been ramping up continuously over the years, sir.
Okay. Now, That's okay. Mr. Williamson asked you the question. The question was, did you witness emission from the bag house? And my question is, how do you do so? You said,
Okay, witnessing emissions are not possible in our operation as far as a visual witnessing.
repeat that visual, say it again?
Emissions from our bag house are not measurable, or you can't witness it in general, in my opinion, because the emission is so very low. If you have 0.00004 pounds or 3 pounds per hour, that's not visible. So you can't see it from that. If you're speaking of the conversation earlier with the visual integrity test of the lead pot, that is something that you can come out, inspect. We can go ahead and literally, it's like a pan, let's say, and you can inspect the bottom of it to see if anything's leaking through. So that crucible integrity test is a visual test.
Because it's not airborne.
Correct.
What part of it is airborne that you cannot witness?
Well, the portion that comes out of the bag house itself, that's what I'm saying, because the input and output is so low to start with. That part you can't actually witness. But the visual integrity test on the lead pot is something you could very easily witness and inspect.
To your understanding, is any portion of the emission that becomes airborne can be detected, yes or no, at this point in time, without monitors?
You can, if the emission is high, you could visually detect it, but at a very low emission rate, I don't believe so.
So, order number one is something that I raised early on. Now, you explained visual integrity test. Would you repeat that? That's in order number one. Tell me what that is.
Just to clarify, that's condition number 1 of the order that's proposed on page 6.
Yeah, on page 6.
Yeah, the visual integrity test, the way that the lead pot is designed, it's basically a bowl or a bucket that's heated from underneath. What we can do for the district is we can remove that heating assembly, and we can actually inspect the integrity of that to make sure that there's no leaks present. And a leak would be very apparent, sir.
And the purpose of ensuring is the free defects. Defects, how do you determine it is free of defects?
It would be similar to, a bucket of water. If it's leaking, you will be able to see it immediately.
And in proper working conditions?
Correct.
Have you, up to this point in time, have you discovered any defects in the operation of the equipment?
No, sir.
If you have not discovered any, then what's the purpose of putting it in the order?
The purpose for bringing the order, from what I can understand, is to get us on a timeline for compliance with the district's rules and to go ahead and get an ambient air monitoring plan, ambient air monitoring in place in a much shorter time frame than if we were to wait for the ambient air monitoring plan process to play through. From what I understand of the order for abatement, I'll have approximately 30 days to start collecting data. If, on the other hand, we wait for the ambient air monitoring plan to go through the district's permitting process and us to get the bag house and such in, we're going to be 6 months ballpark. I haven't calculated this out, but it'll be quite a bit down the road.
In that operation, what would you consider defined to be fugitive emissions? In that operation, what's that? That's part of that's line 11 of the order.
I apologize, sir.
Page 6.
1 second, please.
11, fugitive emission source to observe.
Page 6, item 11, sir?
Yeah. Line 11.
Or line 11, I apologize.
Is on page 6? Line 11?
Line 11, and this is under the visual integrity test, and it's, it says if defects or other fugitive emission sources are observed.
I'm very sorry, are you speaking of the petition or the abatement?
Yeah,
the
I
proposed
don't
abatement?
see that in the
Stipulated
proposed
order.
order.
Something you agreed to, you read and you agreed to it.
Yes, sir.
No,
I'm
no, no,
sorry.
sorry. It is in the proposed order on page 6. It is under condition 1, and it is on line 11.
I don't see a reference to fugitive emissions.
It says right here.
Do you have a different proposed order than we do? It says, if defects or other fugitive emission sources are observed.
Did you zero-copy him?
Do we have
I
a
have the
different?
signed copy.
How is that possible?
Nevertheless, without even finding it, sir, let me try and address your issue.
And let me just, maybe so that we can all be on the same page, maybe if you can find, is that in your order, is that where condition number 1 is? The visual integrity test?
This is the signed, I am looking.
Why don't we go off the record for a minute, just to make sure that the attorneys are on the same page?
Back on the record? Yeah,
Go back on the record.
my apologies. Council and I were looking at the same order. It just had been reformatted before filing with the hearing board so that the lines would line up with the numbers, and so we did not see that on our version of line 11.
So we're,
But
just
it
so
is in
we're
fact
sure we're
right.
on the same page, it is the
Yes.
third line up from the bottom under condition 1 visual integrity test.
That is correct.
Okay.
Thank you.
Okay, does the witness recall the question?
Okay. From what I understand, the question was, would there be any other possible fugitive emissions? And what would those be from the visual integrity test?
Right.
Okay, so the other fugitive emissions would be, let's say, and the district might be able to better answer, but I believe that it would be if our current baghouse venting system is not working properly, it's not being maintained properly, they could see that, some emission from the lead pot, instead of being channeled to the existing baghouse, isn't going where it needs to be. And I need to address those immediately.
In your view, what are fugitive emission? What are they? Could you define?
Fugitive emissions in general in my facility is, if something's on the floor, literally, and you walk across it, you can get a little puff of emission from that. And the way that we address it is trying to do housekeeping constantly, keeping the areas wet to go ahead and keep any type of dust down.
On the floor, there are chips. Those are little particulates
Correct.
that's observed. That which is airborne, which is also could be fugitive, how you determine that?
How do we determine how much is airborne?
Yeah.
Well, currently the building is a total enclosure, and it is vented to the bag house that we have existing now, but we can't determine exactly how much is, without this order, outside the building, if we're going to meet that ambient standard. We believe we will, but until we go ahead and get the actual ambient air monitoring in place, we don't have that data.
I'm trying to determine the fugitive emission atmospherically in the atmosphere. You can't detect that, can you, inside?
Correct.
Atmospheric conditions.
Correct, but based on, the old data that we had from old source testing from many years ago, it was quite low.
Okay, final question. You read these stipulated order, right?
Yes, sir.
You understand it, right?
Yes, sir.
You accept it, is that correct? Yes
Yes,
or no? And do you feel that you can comply with it?
Yes, sir.
So, that being the case, all these other questions that were raised regarding target dates, time, and rules and so on, you already said you accept
Yes, sir.
stipulated to.
Correct.
Okay. Now, you've heard of cost growth, you heard of delays because equipment may be late delivered, you can't comply and timely. Have you thought of any reason why, anything that you would do in the event that you're unable to meet these target dates? That's just stipulated in order. Timelines, they're just timelines.
From what I understand, that's not an option for me. I have to meet the target dates as far as construction, and that's it. And as far as, my understanding is if I don't meet those timelines, then the district has got shutdown capability on my facility as a result of me failing to meet those timelines.
So the enforcement section would take a look at that. Because here in the first order, you have to call the district in when you perform these tests. You understand that?
Correct.
Okay, very good, thank you.
Anyone else have any questions for the witness? Okay, seeing none. Mr. Williamson, do you have any other witnesses?
I do not.
Oh, you know what, I did have that question. And I don't know if, Mr. Sloan, if you want some time to consider it, but I do want to know before we ask for public comment, if there is any, and go into closings and deliberation and close the record, whether you would consider a condition, because it is a stipulated order, that would have the facility stay at the current level, not go lower than the current level, until the new bag house is put into place, rather than waiting until the monitors are in place and we know whether there's any exceedances. Given all the testimony, I think that would be a more fair provision. So
I have proposed language for that if
that
that's
would be
something
very
that
acceptable.
respondent would consider.
If you want to answer now, otherwise we can take a few minutes off the record. Yes. So why don't we do that when we take, would 5 minutes be? Okay, so let's take 5 minutes off the record. We're back on the record.
If we just go to closing, I can address all remaining issues in closing.
Okay. Do we need, though, on the record, testimony of the respondent as to whether?
Oh, okay, we could
would
do it that way.
approve-
If you then would allow me to just present the condition?
That would be great.
Okay. What I would anticipate is that this would be inserted after the first sentence in paragraph 4 under the order on page 8, which is entitled New Equipment. After the application number, it should state, respondent shall maintain current production levels as determined by average production levels during 2017 until the new bag house is installed.
Okay, so respondent shall maintain current production levels as determined by average level, what was that?
Average production
Average.
levels during 2017. Until the new bag house is installed.
Okay, and then, if you don't mind, I just have one question. Did you have something else before
I
we?
was just going to ask Mr. Sloan if he's willing to comply with this.
Before you do that, I just wanted to just clarify. So I think you answered this, but I want to be clear. Your current production levels, which are below your average levels generally, they are similar to the average levels in 2017?
That's correct.
Okay, thank you. And I'll let Ms. Feldman ask you if you.
Can you tell me where this addendum is?
Yes, it's on page 8. Item 4, entitled New Equipment.
Gotcha.
Right, and it follows that first sentence there.
Thank you.
Do you want to ask?
I never officially asked, Mr. Sloan, are you willing to comply with this new requirement?
Okay, with that, before we go to closing, I'm going to ask if any member of the public wishes to be heard on this matter. Seeing none, Ms. Feldman, you're closing.
Yes, before closing, I'd like to just make a couple of points of clarification. For the senator's benefit, 1420.2 C8 does define fugitive lead dust, and it means any solid particular matter containing lead that is in contact with ambient air and has the potential to become airborne. So that's what we mean by fugitives in this order. Also, to give Ms. Prusak some context, when she questioned respondent about the significance of the .00003 pounds and how that might compare, I don't have a comparison for you, but the rule 1420.202, which is on page 26 of the rule, provides an exemption for lead point source emission controls, and it says any lead point source that has an uncontrolled emission rate of .005 pounds per hour or less shall be exempt from the requirements of subdivision F of this rule, provided that a source test pursuant to subdivision J is conducted for the lead point source at least once every 24 months. So that's just to give you some context as to what that number means. It's clearly lower than the exemption, but has not been substantiated by a valid source test. Okay, that being said, in closing, no one. That was 1420.2 O, as in Oscar, 2. It's on page 26 of the rule, if you want to look it up. So in closing, I just want to briefly state that no one is suggesting that this facility hasn't had a long history of noncompliance with district rules. A respondent would undoubtedly characterize it a little differently and say he has a long history of misunderstanding between the district and himself regarding interpretation of rule requirements, and that has been going on for a protracted period of time. But what we are focused on now is getting this facility in compliance as expeditiously as possible. Obviously, we're not here seeking a variance, which would clearly not be available to respondent. And respondent has been cooperative during this process, and even where he still maintains disagreement with the applicability of rules, he has deferred to district's determinations as to whether permit applications should be submitted and whether controls are required. In terms of the value of this particular order for abatement, as respondent himself has indicated, it puts him on a fast track to get, at this point, the monitoring in and monitoring being, the monitors in and monitoring being performed much more quickly than the rule would allow under its own schematic. Under the rule, he would have 90 days after submission of a new plan, which would have to be approved regarding location of the monitors and valid source tests and all that. You will note in this order, he has 3 days to start the process, and within 30 days, we're going to start getting our monitoring results. So we have shortened timelines for getting the monitors installed. You'll see that on page 6, paragraph 2. And operating, daily monitoring will be performed. A curtailment provision will protect against any high lead emissions. If the monitors start triggering in ways that we are not anticipating at this point, there is a backstop to that built in. And I want to assure the hearing board as well that if things don't go as expected, and we do see high lead readings, high lead concentrations at these monitors, and we do not believe that the new bag house and the improved housekeeping proposed by respondent is going to address those levels in the short term under this order for abatement, we will have the basis to come back and modify the order with evidence of what the emissions are to justify any additional measures that the respondent might need to take in terms of improved housekeeping to control fugitives or enhanced controls on his equipment. The reason why we're seeking this order in this form at this time is to expedite that, getting to that point where we can all make an informed decision about what is happening at this facility.
Thank you, Ms. Feldman. Mr. Williamson, your closing.
Ms. Feldman covered most of the topics I would cover, but I would just reiterate that the last 2 years and certainly the last 3 to 4 months have seen a very fluid situation, significant change with approach, with both permitting and monitoring. It has made the path forward, especially at the beginning of this year, look very unclear for all parties. And the conditions laid out in the order we have discussed them. My client is ready to comply with them. We have a path forward. It is easily the most expeditious way that we can get into a monitoring and permitting situation where both parties are happy. And so we urge that good cause exists to grant the order. And on that, I'll rest.
Thank you. Board members, I will be happy to begin discussion on this. And I think after all of the testimony we've heard today and the evidence, I think there is good cause to grant this stipulated order for abatement as has been modified during the hearing. I was concerned definitely, whenever we talk about lead, as the senator was pointing out, whenever we talk about lead and we talk about, even though this is a highly industrial area, the nearest resident being 1,225 feet away, and mostly the fact that there is so much uncertainty as to what the emissions are. However, with that said, there are several things that give me solace as to whether or not this will be effective and that the community is not going to be overburdened with lead emissions. First of all, it is not a proper source test because the subcontractor was not, wasn't an allowable subcontractor. However, the results, as Ms. Feldman pointed out, were well below what the exemption is under the rule. Of course, that will have to be redone and with the new bag house. Also, the respondent has agreed, has testified to the extent that current levels of production are far below the permitted level and far below even what are the average, and has agreed for about the first 60 days, a little bit longer, to keep at those levels, those lower levels. Once that's done, then we'll have the new bag house in place, and certainly we'll have some monitoring up and running, because that will be within about 33 days, and the first 30-day rolling average will be coming in by that time, and then there will be by the terms of this order for abatement, there will be a mechanism in place that if there is exceedances on those monitors, the facility will have to stop all lead processing at that point. So with all of that in consideration, and the fact, as has been aptly explained, that this will get those monitors in place much quicker and get everything rolling, I think, as it stands now with those changes. And with one other change, which I would talk about at the time of a motion, but before that, that I think there's good cause. I see, Mr. Camarena, you had some thoughts.
I fully agree with your comments. I did have some concern regarding 1407. Mr. Sloan explained that he believed that Rule 1400, I think it was that one, exempted them from 1407. Mr. Williamson directly asked Mr. Sloan the question I was going to ask, and that is, well, what did you do about that? Did you ask for clarification? And we got the answer. And I think also that there's no record of the district having issued a notice of violation for that section of the rule. Certainly would give Mr. Sloan further confidence that there was indeed no violation. We don't know if that doesn't exist because it was overlooked by the inspector, or there was no inspection made, or the district also inspector also agreed with that view. The order for abatement is a prospective tool, and as explained by Ms. Prusak, I believe that it puts the respondent on a path to get into compliance as soon as possible. I'll stop there.
Any other thoughts? Ms. Byrd?
I agree that we can find good cause, and I think as we looked at the schedule, that this does put them on track, and as Ms. Feldman elucidated further in her closing, how this puts them on a faster track than if they were to just follow the timetable that the rule allows. And then the other thing that gave me a little more comfort as well is even this order says that even if they shut down because they've exceeded, once the monitors are in place, they still have to put in all their air pollution control equipment. So it would be there should they be able to start back up again. This will not preclude them from having to continue to put everything in place as far as the controls go. So I find some comfort in that as well.
Anyone else have any thoughts? Discussion? Dr. Lerner?
Yeah, I'm in agreement and largely with what everybody said, but I must, as the most layman of the five here in terms of understanding the complexity of this, I think for purposes of clarity, it would be better if we had a timeline presented about all the different areas that needed to be accomplished, and so we would be able to see it graphically, and I have to flip back and forth. Other than that, I think I am in agreement. I would like to see this done expeditiously, and those are my thoughts.
Just one thought. I agree that timelines are generally much more helpful. Most of the conditions in this particular order, though, are triggered off of permitting and source testing, and so it's hard to know which is going to come, which, when, and so I think that's probably why we didn't get a timeline, but I agree generally that's always helpful. Anyone else have any thoughts that they would like to add to the discussion? Okay. I'm going to make a motion, but first I wanted to say a technical issue that I have with the order. Under the Health and Safety Code, Section 42452, form of order, all orders for abatement need to take the form as a writ of injunction requiring a respondent to refrain from a particular act. And while it can be conditional, that has to be or in the alternative.
I apologize for that. That
That's
was,
okay.
That was a simple oversight on my part.
I have language to
I
propose.
neglected the cease and desist language.
Well, if you have better that we would normally use, my only suggestion, I just want to make sure that it's acceptable to both sides, is, and this would be on page 6, if you want to follow along, right under the order, just in the therefore clause, respondent is hereby ordered to, and then we would insert there, refrain from any operations in violation of any district rule or regulation, or in the alternative, comply with the following conditions.
That's acceptable to the district.
Acceptable?
to respondent too.
Okay, thank you. So with that, in the matter of South Coast Air Quality Management District versus Industrial Battery Engineering, Inc., case number 6100-1, I move that we approve and adopt the proposed findings and decision for order for abatement, which is stipulated with the following changes. We remove the word proposed from the header, from the title and from the footer. On the first page, I have been corrected that, or been made aware that on line 23, it's either Dr. Roger Lerner or Roger Lerner, MD. So I will remove the doctor from that and just leave it at Roger Lerner,
You're being
MD.
removed?
Nope, just one of the two bookend titles. More to the point, I will add, my motion will add to page 6, on line 5, right after the words respondent is hereby ordered to, the words refrain from any operations in violation of any district rule or of any district rule and regulation, or in the alternative, comply with the following conditions. Then on page 8, what we have as, well, it's condition number 3, permit applications, rather than referring to lines. At the very end of that first paragraph, before the little Roman numerals, Romanettes, expedite processing for, instead of the following equipment, that would be deleted, and little Roman numeral, Romanette number 1, that whole thing would be deleted, since that has already been, right, that one has already been applied for. We would leave Roman numerate number 2 in, but take out the little i's, and instead just continue with that line for modification to existing bag house permitted under G 2872, and then we would have a period there, and Romanet 3 is also deleted because that will not be used. And then finally, in condition 4, we're adding a second sentence, and that sentence shall read, respondent shall maintain current production levels, comma, as defined by average production levels during 2017, comma, until the new bag house is installed. Very hard to read my writing. Okay. And everything else will remain as is proposed, and that completes my motion. Is there a second?
I'll second the motion. I have a couple of I's that perhaps need dotted. First of all, on the last page, we have conditions 10 and 11 that are duplicated on page 9.
Oh, okay.
So
So then I will accept as part of the motion to delete one set of conditions 10 and 11.
I have,
The ones on 9,
go ahead.
I was going to say, number 11 that's on 9 is not a complete sentence.
Yes. And I suspect that has something to do with the fact that there are two versions circulating.
I think that was a casualty of the reformatting.
And so I don't believe that any complete version will have two 10s and 11, but if they do, my motion will be to have only one condition 10 and only one condition 11.
I have a few others. On page 6, line 11, let me read the sentence. If defects or other fugitive emission sources are observed, respondents shall immediately cease all operations using the crucible until the equipment is repaired or replaced and inspected by the district. And I guess my question to the district, do you wish to tie that down so that it says, and inspected by the district and found something that says satisfactory?
We could say inspected and approved
Okay.
by the district if that's acceptable.
And is that acceptable to respondent? It's acceptable. Thank you. And so that is acceptable as part of my motion. So it would be inspected, replace and inspect replaced should be replaced, comment, and inspected and approved by the district. Okay. So just adding the words and approved.
Okay, on page 6, second line from the bottom, at the end of that line, I would be more comfortable with word shall instead of will.
That's acceptable to the district.
Okay, and then it's acceptable to the motion maker. So it's 2 lines from the bottom. I'll read the sentence just in case, when Madam Clerk, when you are going over this, you are on a different pagination. It says, upon approval of the plan, and if the district identifies preferable locations, comma, the monitors and wind monitoring station, instead of will, it will now be shall be relocated.
The last one I have, not sure that, it would be nice to have it, but I'm not sure that it would work well in practice. Page 7, line 17. I'll read the sentence which starts at line 15. The facility may resume operations when the rolling 30-day average lead concentration is less than or equal to 0.100 micrograms lead per cubic meter, contingent upon notification to the district as described under this order. Contingent upon notification to the district. It would be a little tighter if it said and approved by the district. But I don't know if that would take an inordinate amount of time.
I don't know what the process would be for that. We are attempting to make these curtailment provisions as consistent as possible between all these orders. This is actually from, I think, the Anaplex order, and you'll see it coming back at you from time to
You
time.
don't have to make the same mistake over and over again.
No, I am very fond of saying, it's one of my mantras around here, that error is not precedent.
Okay.
But it's working so far, so
You're happy with this?
yes.
Okay. I have no other changes.
Thank you. Any other discussion on the motion, board members? Okay. Oh, Dr. Lerner?
Point of clarification for me, the word vacuum now is only applying to the new vacuum. Is that correct? Remember we
The word
talked about-
vacuum has been, in that situation, has been
Yeah,
deleted.
Remember in
Has-
Romanesque
Has
3?
been deleted.
What?
That has been deleted.
Oh, it has? Oh,
Yes.
Wonderful, I'm sorry. I didn't get that. Okay, dandy.
So I've rewritten that, but both Romanet 1 and Romanet 3 have been deleted.
Good, fine, thank you.
Any other discussion? Okay, seeing none. Senator, how do you vote?
I vote no. And I want the clerk, I vote no. I want the clerk to take down the reason why I'm voting no on this Industrial Battery Engineering, Inc., the matter before us today. My reason is the district, there's no evidence that the people living 1,200 plus feet away from this site that's been operating for nearly 60 years, that they may be subjected to the lead contaminants, poisonous material. Notwithstanding the fact the district said they're going to install monitors, it's been stipulated to in this agreement. The monitors are going to be surface collectors or also airborne. It's not yet been determined. There's no evidence. If it's surface collected, then the district, in my view, should have done an outreach program in the community where there's a lot of surface there. They could have obtained residue from areas in that community and determine whether or not the people living there, therefore, would have been over the years subjected to this contaminant. There's no evidence introduced today to say anything like that was done. So it's my view, the district could have done more than what they did in order to say, fine, you have additional time to make these corrections to the problem that we've identified. They did not. And for that reason, public member, I have to make the point. And I'm voting no. Hope the clerk took that on. Thank you very much.
Thank you, Senator. And before I ask for others, for the vote of others, I just wanted to just respond briefly, because in my discussion, I definitely addressed the fact that I had concerns, as you do too, that the nearest resident is 1,225 feet away approximately, and that this is lead. But I also discussed the fact that throughout the hearing, there were many bits of evidence through testimony that made me feel more comfortable that, in fact, it's unlikely that it's less likely that this facility is over any limit. First of all, the fact that this facility has been operating at well below its average and well below its permit limit, and that they have agreed as part of this order to maintain those levels until the new bag house is placed is installed. That gives me a lot of comfort. Also, the district had testified that the reason why they do not believe that this facility is above its emissions limit, at least the inspector testified, because all operations are within the total enclosure, which helps. Also, there was testimony from respondent with regard to the source test, which was not a proper source test. There's no dispute about that. And that has to do with a subcontractor that was not on the list or proper. However, the results of that source test, which is the only thing we have right now, showed very low, 0.00003 pounds per hour, which is well below the exemption limit in 1420.2. And also there was some testimony, although there was no actual evidence of the test itself by Mr. Sloan, that the last source test, which was years ago, was also in compliance, and years ago he also testified that the levels of operation were much higher than currently. So it is for those reasons that I feel comfortable, and also just so that you know, what we approved today, the order is within 60 days, essentially 63 days. If there's any rolling average above 0.1 micrograms of lead per cubic meter, which is the new, more stringent standard that takes effect in April, that the facility will shut down until it's back in. So with all of that, I do feel that the community is being well protected by the order prospectively.
I'd like to add to my no vote, add by further stating, based on the recent response, that the district strongly feel, obviously, that the emission exceeding a certain level, notwithstanding the level they mentioned, that's why they're requiring or demanding that you have monitors.
The monitors are being required as part of 1420.2.
That's a stipulation, yeah, but the monitors are there based on the amendment on 1420.2.
Right, that required the plan, which was never approved.
I understand that, but the fact of the matter is that being the case, they are required and they will be installed. And it's felt strongly by the district they are needed. That's why they're being installed. There's no evidence, again, I repeat, if it's depending on the collector device, surface device, the district, in my view, should have gone out into the district with people living in this environment for nearly 60 years and perform some residue tests to see what they've been subjected to. And then those people have not been notified about this hearing today, not to my knowledge.
The proper notification of this hearing, as of all hearings, was provided to the public.
Was it in what way?
I believe it's publication in a newspaper of it's what's required under the Health and Safety Code,
Anyway,
Senator.
This is such a deadly contaminant that there should be somebody in that community concerned enough to be here, but they're not. Thank you.
Thank you, and hopefully,
Madam Chair.
oh yes, I was just going to say, and hopefully, if the district deems it important enough or more as a problem enough to improve their rules in terms of going out and doing what you suggest, but in this case, there are only monitoring rules, and this order will bring those monitors there much quicker than would otherwise. Sorry, Mr. Camarena.
Thank you, Madam Chair. While we all may have some concern to a varying degree about the past, we are here today, and the decision is, do we want to adopt this order, which places the respondent on a path to earlier compliance, or not? The not would bring compliance to a much later date. The alternative is for you to have offered a motion to deny, or to rather to require complete shutdown, if that was your pleasure.
That's up to the district, not me. I'm just casting my vote.
Well, I want to make sure we understand. I appreciate your concern for the community, and I share it. But now or in the future, if this motion fails, you are free to move to, for an order for abatement to shut down the facility. So your no vote, okay. Unless there's more discussion, I'm gonna move to Dr. Lerner for your vote.
I vote yes with one comment. The district, it would have been helpful to the district, and I was asleep at the switch. I should have asked about the proximity of the closest school, because we're really concerned in the future about the kids. The old folks, the kids.
Well, if we want to reopen for that,
No, we're not.
oh, we don't
No,
need
we're
to,
not.
okay. I was going to say,
Comment. I wish it happened.
but for sure, 1,225 feet away, there are sensitive receptors. That is the closest sensitive receptor, which would be, resident, child, elderly.
But they only mentioned houses. They specifically did not say school, so I don't know. I can't say. I just wish they had. That's what I'm saying.
Thank you for that.
Can I address I can vote, I will vote yes, but I'd also like to address that there was testimony that public notice, Rule 212 was not needed for public notice because there was no school within 1,000 feet. That was testimony that we heard.
It was receptors. Oh, that's right.
No, you said school, so I just wanted to mention that
Yeah.
they did address that there were
You're
no
absolutely correct. I forgot that receptor phrase is inclusive to schools.
Okay, and I vote yes.
Okay, and Mr. Camarena, you vote yes, I assume?
I vote yes.
And I vote yes. So the motion passes 4-1, and the order is granted. Thank you all.
Good luck.
And good luck is right. And board members, any other business before we adjourn? We are off the record and adjourned. Thank you.